In the previous two lectures, I have discussed the two archetypal excusatory defenses in Canada, necessity and duress. In today's lecture, we move to two justificatory defenses, defense of person and defense of property. These are relatively new provisions, at least in their current form, having simplified and replaced earlier provisions. The changes were more than cosmetic, and only recently worked their way through appellate courts. And so we are only starting to get a sense of how they will be interpreted and used. In 2013, the self-defense and defense of person provisions in the Code were replaced by a new streamlined provision, the new Section 34. Here is Section 34 sub 1, and it states, a person is not guilty of an offense if A, they believe on reasonable grounds that force is being used against them or another person, or that a threat of force is being made against them or another person. B, the act that constitutes the offense is committed for the purpose of defending or protecting themselves or the other person from that use or threat of force. And C, the act committed is reasonable in the circumstances. And then if we turn to Section 34 sub 2, we see a laundry list of factors that were intended to help us determine whether or not the act committed by the defendant is reasonable in the circumstances. Our leading case on Section 34 is, at the moment at least, the Ontario Court of Appeals decision in the Queen versus Kill. Now, in reading and thinking about the decision in Kill, keep in mind that the Court of Appeal was concerned only with the use of Section 34 by defendants claiming, in effect, self-defense, and not defense of another. For these purposes, Mr. Justice Doherty emphasized the large, though not complete, degree of continuity between the old self-defense regime and the new Section 34. He made a number of observations about each of the subsections, and so it's helpful to return to the text of Section 34 sub 1. Let's start with Section 34 sub 1 sub A. This subsection makes it clear that in order to claim self-defense, the defendant must have had a subjective belief at the relevant time that force was being used or threatened. Mr. Justice Doherty described this condition in Kill as the triggering condition for self-defense to be on the table. In Kill, Mr. Justice Doherty found that in determining whether the triggering condition is satisfied, we are not simply to ask whether the defendant subjectively believed that force was being used or threatened. The belief must be reasonable. At the same time, the reasonableness inquiry will take into account the defendant's personal circumstances and experiences where these are relevant to his beliefs and actions. Thus, previous violent encounters with the victim or knowledge of the victim's propensity for violence might help us assess the reasonableness of the defendant's belief that the victim was using or threatening force against him. Furthermore, Mr. Justice Doherty found that we may consider any mental disabilities on the part of the defendant when assessing the reasonableness of the defendant's belief that force was being used or threatened against him. In conducting the reasonableness inquiry, however, we are not to take into account all of the defendant's personal circumstances and experiences. We are not, for example, to consider the defendant's state of self-induced intoxication, where the defendant was abnormally vigilant. That too will not be brought into the analysis. nor will background beliefs of the defendant that are antithetical to fundamental Canadian values and societal norms. Thus, for example, an accused's honest belief that all young black men are armed and dangerous could not be taken into account. In Kill, the defendant had previous military training. Could that be taken into account when assessing the reasonableness of his belief that force was being used and threatened by the victim? In Kill, Mr. Justice Doherty concludes that the answer is yes. Why? Well, the language of Section 34 sub 2 is quite broad and open-ended in that reference to relevant circumstances. Furthermore, Mr. Justice Doherty observes that police training and experience have been thought germane when assessing reasonableness under both Section 34 and under Section 25. Moreover, considering the defendant's military training wouldn't have the effect of making the inquiry into whether or not the triggering condition is satisfied purely subjective. So that's the trigger. Section 34 sub 1 sub b sets out the motive condition. So here's Section 34 again, and note that sub b provides that in order to claim self-defense, the act that constitutes the offense must be committed for the purpose of defending or protecting oneself or another person from the use or threat of force in issue. As this suggests, the defendant must act for the purpose of defending himself or another. It is not enough that force is used or threatened and that the offense committed by the defendant has the practical effect of averting or repelling the threat. It must be committed for the purpose of averting or repelling the threat. Thus, responding with force to a threat or use of force in order to retaliate would in principle disqualify one from relying upon the defense. Now, that said, we may have evidence of such a motive only or mainly when the defendant continued to apply force after the threat was effectively repelled. Finally, we must consider the response. The defendant's response to the threat or use of force must be reasonable in the circumstances. And here we must consider the factors set out in Section 34 sub 2. And what are some of the factors? Well, I'll just read out subsection 2. In determining whether the act committed is reasonable in the circumstances, the court shall consider the relevant circumstances of the person, the other parties, and the act, including, but not limited to, the following factors: the nature of the force or threat, the extent to which the use of force was imminent and whether there were other means available to respond to the potential use of force, the person's role in the incident, whether any party to the incident used or threatened to use a weapon, the size, age, gender, and physical capabilities of the parties to the incident, the nature, duration, and history of any relationship between the parties to the incident, including any prior use or threat of force and the nature of that force or threat, any history of interaction or communication between the parties to the incident, the nature and proportionality of the person's response to the use or threat of force, and whether the act committed was in response to a use or threat of force that the person knew was lawful. Now, at least arguably, many of these factors that are set out in section 34 sub 2 are relevant and germane to the reasonableness inquiry because they go to whether or not the defendant's use of force against the victim was proportionate, whether it was necessary, or whether it went beyond what was necessary, and whether or not the defendant was reasonable in believing that the use of force applied to the victim was necessary under those circumstances. So, for example, some of the factors set out in section 34 sub 2 concern the personal characteristics of the defendant relative to those of the victim. That makes sense, because the kind and degree of force that would be reasonable under the circumstances may depend in part on the relative physical characteristics of the actors, and indeed whether or not one actor or both were armed. Quite simply, the sorts of force that might be reasonable when trying to subdue an armed and much larger attacker might not be reasonable when one is attempting to subdue or repel the use of force by someone who is much smaller or unarmed or both. And some of the factors set out in section 34 sub 2 concern the defendant's history with the victim. Now, why might that matter? Because what responses are or are perceived as reasonable may depend on prior interactions, suggesting, for example, that the other party will give no quarter, or may indeed escalate the attack if met with relatively minor uses of force. So, arguably, at least, many of the factors set out in section 34 sub 2 go to what we might just think of as proportionality. And that is notwithstanding the fact that proportionality itself is, at least on the face of it, merely one factor among several in section 34 sub 2. Under the old self-defense regime, the defense was categorically barred under certain circumstances. For example, the force used in self-defense could not be greater than necessary. Moreover, the defense was limited where the initial attack was itself provoked by the defendant. Now, the new section 34 more or less lumps all the factors together, leading to a much more open-ended and flexible test of reasonableness. There is, however, a possibility that the Supreme Court may require significant guidance from the trial judge as to how the trier of fact should approach the weighing of factors. In other words, the Supreme Court may attempt to build some structure into this weighing of factors that is otherwise, again, left pretty open-ended in section 34 sub 2. And indeed, in Kill, the Ontario Court of Appeal required an instruction giving special attention to the factors that were especially salient in that case, rather than simply telling the jury to consider all factors equally, irrespective of their particular relevance in the case before them. Section 34 sub 2 states that the defendant's role in the incident must be considered when assessing reasonableness. Previously, provocation by the defendant would either disqualify him or her from claiming self-defense altogether, or limit availability of the defense. This is no longer the case. But section 34 sub 2 suggests that the trier of fact may consider the fact that the defendant provoked the attack when assessing reasonableness. Indeed, there may be, as I said, a duty on the trial judge to draw special attention to the significance of the defendant's role, depending on the evidence adduced at trial. Now, Section 34 sub 2 would seem to treat proportionality as but one factor. In principle, an act that is, strictly speaking, disproportionate to the use or threat of force may still be reasonable within the meaning of Section 34 sub 1 sub c. But one would think this an important factor, particularly since many of the factors listed in Section 34 sub 2 presumably draw their significance from the fact that they make the use of defensive force used by the defendant more or less proportionate as a response. That proportionality is listed as only one of several factors may simply reflect the fact that a person under attack cannot be expected to weigh to a nicety the degree of force used in response. Imminence, too, is only one of several factors to be weighed in the assessment of reasonableness. This, in fact, had been the legal state of affairs since the Supreme Court of Canada's decision in Lavallee. There, the court made clear that one could claim self-defense even where the threatened harm was not imminent, that the lack of imminent threat was merely one factor to be considered when assessing the reasonableness of the defendant's conduct. As in Kill, the Supreme Court of Canada in Lavallee emphasized that the assessment of reasonableness should take into account the personal circumstances and experiences of the defendant, at least where those beliefs are not contrary to social norms and values. Thus, expert evidence in Lavallee that the defendant suffered from what is colloquially described as battered women syndrome would be relevant to the assessment. The mere fact that the defendant had an opportunity to retreat rather than employ force to repel the perceived attack does not disqualify the defendant from claiming self-defense. As a general proposition, the decision not to retreat is merely one consideration to be weighed when assessing the reasonableness of the defendant's conduct. Indeed, in Cormier, the New Brunswick Court of Appeal held that it is reversible error to claim that the failure to retreat in itself negatives self-defense. This proposition is, if anything, strengthened where the attack occurs in one's own home. For there is a long-standing proposition that there is no duty to retreat under such circumstances. Let's return to Section 34 sub 1. Notice that Section 34 sub 1 is not limited as a defense to cases in which the defendant is accused of, say, assault or murder. It simply states a person is not guilty of an offense if the three criteria set out below are satisfied. So Section 34 does not serve only as a defense to charges of assault or murder. In principle, it can provide a defense to any criminal offense committed in order to repel or avert the use or threat of force by another. Now, what sorts of offenses might one commit in order to repel or avert the use or threat of force by another? Well, we can readily think of some examples. Perhaps stealing a car in order to, again, escape attackers. breaking and entering into a home or building in order, again, to escape an attacker. In effect, Section 34 allows a defendant to claim defensive person in many circumstances in which one previously would have had to claim necessity. And arguably, with a more forgiving legal test, since Section 34 is a justification and not an excuse. Consider how the case of Ryan might have proceeded differently if the new Section 34 had been in place at the time that the defendant tried to hire the hitman to kill her husband. Recall that the hit never occurred because she actually approached an undercover police officer by mistake. So the charge was not murder or assault, but rather an attempt to commit an offense not committed under Section 464 of the Code. That meant that she couldn't claim self-defense, which wasn't available as a defense to that charge. So the defendant tried to argue duress instead. The Supreme Court said in reply to this, no, you can't do that. Duress requires someone to make an explicit threat, in effect, commit this offense or I am going to hurt or kill you or someone else. That didn't happen in Ryan, and because self-defense is a justificatory defense, the Supreme Court held that it falls to Parliament to establish its boundaries. We're not going to let you try to stretch the statutory justification, the court effectively told Ryan, by inventing some kind of hybrid self-defense / duress defense at common law. But what if the new defensive person scheme had been in place when Ms. Ryan approached that undercover officer? The new Section 34 doesn't limit defensive person to cases of assault or murder. And on the evidence adduced by the defendant in Ryan, what do we find? Well, we seem to have evidence supporting the suggestion that the trigger condition is satisfied, because Ms. Ryan adduced evidence that there was a perceived threat of force against the defendant and her daughter. The motive condition arguably has some evidence supporting it, because ostensibly the attempted hiring of the hitman was undertaken in order to quell the threat. And finally, Ms. Ryan's response. Well, it may be a close call, but when you consider the factors set out in Section 34 sub 2, it at least isn't obvious that her conduct couldn't be regarded as reasonable under the circumstances. And in any case, whether she could have succeeded or not is really beside my point. My point is not that Ms. Ryan would have succeeded or that she should have succeeded in raising defensive person in this sort of alternate universe, though some have argued that such a defense would and should have succeeded. My point for now is just that defensive person would not have been ruled out in advance in the Ryan case. Finally, and returning to a point that I noted earlier, Section 34 is not a, strictly speaking, self-defense provision, but a defensive person provision. It unambiguously allows one to commit an offense to defend anyone else, not just yourself or perhaps someone under your specific protection. How this might affect the reasonableness analysis mandated by Section 34 is as yet unclear. Consider, too, Section 35 of the Code, which was enacted at the same time as the new Section 34. Here is the new Section 35, sub 1. And it states that a person is not guilty of an offense if A, they either believe on reasonable grounds that they are in peaceable possession of property or are acting under the authority of or lawfully assisting a person whom they believe on reasonable grounds is in peaceable possession of property. B, they believe on reasonable grounds that another person is about to enter, is entering, or has entered the property without being entitled by law to do so, is about to take the property, is doing so, or has just done so, or is about to damage or destroy the property or make it inoperative or is doing so. C, the act that constitutes the offense is committed for the purpose of preventing the other person from entering the property or removing that person from the property, or preventing the other person from taking, damaging, or destroying the property, or from making it inoperative, or retaking the property from that person. And D, the act committed is reasonable in the circumstances. This too represents a considerable simplification and unification of the defense of property. There are 4 basic elements to the new defensive property scheme, and here I'm going to proceed on the basis that the defendant was acting in defense of his or her own property and not that of someone else. First, the defendant must have reasonably believed him or herself to be in peaceable possession of the property in issue, in that possession was not seriously challenged by others. Second, the defendant must reasonably have believed that the property was or was about to be interfered with in one of the 3 ways listed under subsection B. If the interference is concluded or the damage already done, the defendant cannot claim defense of property. Third, the offense committed by the defendant must have been committed in order to prevent the interference or stop an ongoing interference. As with self-defense, revenge is not authorized under Section 35. And finally, the response must have been reasonable. The last branch of the test has not been given much statutory elaboration, unlike the equivalent section in Section 34 sub 1. But it would be strange if Section 35 did not also require some degree of proportionality between the interference and the response. It is therefore highly unlikely that one could intentionally inflict lethal force to, say, expel a trespasser or recover stolen goods. At the same time, it is also unlikely that any and all uses of force are precluded. There is an interesting question as to whether the wielding of a loaded firearm, which might otherwise constitute the careless use of a firearm, or unlawfully pointing a firearm, could be reasonable under some circumstances. In Sherbanowitz, a case that preceded the new Section 35, the Supreme Court suggested that reasonableness entails no more force than necessary. And the court in Sherbanowitz suggested that this inquiry involves an assessment of the defendant's subjective belief as to the nature of the danger or the harm and the reasonableness of that belief. That brings me to the end of this brief discussion of the new defensive person and defensive property provisions in the Criminal Code. In the next lecture, we turn away from excuses and justifications to institutional defenses. See you then.